So the way we're structuring this evening's proceedings is I'm going to just do a short recap of the guiding principles of the Future Bar Training Programme. Looking around the room, I think this will be very much revision for many people. So those of you who are very familiar with this, forgive me. I will just introduce a few of the areas of work in FBT and talk a little bit about the one topic that we're not intending to cover in the group discussion this evening. We'll then at the end of that set out the next steps, and as Sir Andrew said, there's a drinks reception. Now for those of you who may be using attendance at this event as part of your continuing professional development, we suggest that the learning outcomes from this evening's event will be around helping you understand how prospective barristers will be trained in the future, and if, for example, you're minded to respond to the consultation, we hope that this will allow you to have a better informed and more nuanced response to that consultation. So, the guiding principles for future bar training, which many of you are, as I say, now familiar with, these have been principles that we've tried to see running through the entirety of our work since 2014, but principles which we really concretised this year. Accessibility, affordability, flexibility, maintaining high standards. What do they mean? Well, those of you who've already looked at the draft authorization framework that's at the end of the consultation document will all know that at the beginning of that framework, we put forward a proposed definition of those principles. I'll say a bit more about that in a moment. So, flexibility. This is about innovation in delivery and the modes of study. Within that, however, we've said that we are minded to be approving in due course 4 main structural routes for training for the bar. That flexibility, we hope, will also allow us to align with some of the regulatory arrangements from other legal professional regulatory bodies. Accessibility is about encouraging admission of and support for students from underrepresented groups. That's very important at the bar. We've made great progress in that area in the bar over the last decades, but there's still more to do, and we need to make that sustainable in the future. Affordability is about bringing down the cost or reducing the risk in the investment. Serious professional training is very rarely cheap, but we can try to ensure that those signing up for it will get better value for money out of what they are signing up for, and as we say, that the risk that's in their investment is reduced. And high standards fundamentally is about assuring the public of consistency in outcomes, that we as a regulator can say to the public, it doesn't really matter how or where a barrister has trained. Once they're fully authorised, we are confident that they have met a minimum standard and that they are therefore safe to practice. There's a lot more in high standards, of course. That's where we place all our material in relation to the centralised assessments, things to do with curriculum, etc. It's where we will also be setting out our arrangements for the recognition or the requirements that we would impose on lawyers coming from other jurisdictions and indeed from other legal professions within this jurisdiction. A reminder that if you like, the fulcrum for everything that we are doing in future bar training is the professional statement. I just took a straw poll. How many people in this room have seen the professional statement? Right, so I don't need to say very much more because broadly speaking, I'm speaking to the cognoscenti. So this is the one-stop shop document that picks up and spells out the knowledge, skills and attributes that we expect a barrister to have on day one of practice. And critically, of course, that statement is now being used to inform the design and in fact already the delivery of education and training pathways for the bar. So just thinking, again, some of you will have seen this kind of slide before, but it has changed a little bit since the last time we explained how the programme is being managed. It is a formally managed programme. Some of you will be organisationally familiar with those principles. And it's divided into a series of projects. There's a project about rule changes, which focuses on changing Part 4 of the handbook, and in particular the application that we have to make to the Legal Services Board as part of the statutory process to change our regulatory arrangements. We're not actually going to talk about that tonight. The Authorization Framework, I'll say a little bit more about in a moment, but again, we're not intending to target the discussion on the Authorization Framework tonight. Pupillage and the role of the INS, self-explanatory in terms of the title of those projects. Those are the two that we hope to focus on this evening. We're also reviewing the curriculum and assessments for bar training. That links very much to the Authorization Framework. Again, we're not focusing on that tonight, and indeed we're not focusing on that much in the consultation either. I'll say in a moment why that is. We have added a new project, and this is around the recruitment and advertising arrangements for pupils. And again, we don't want to major on that in the discussion this evening. So, what is the Authorization Framework for? Well, it's fundamentally the manual against which we will authorise new providers and routes of training for the bar. We're going to test people's proposals against it. What you see in the consultation document has been drawn up by a group of external experts and executive staff with particular skills and experience in that area. Again, everybody knows that historically we've had very tightly prescribed requirements for training within, for example, the Bar Professional Training course. We're now going to be allowing a more diverse range of pathways, but we still, of course, have to have a means of assessing proposals for delivery of education and training, and it needs to be transparent and systematic, and that's fundamentally what the framework will give us. So it's there as an annex to the current consultation. It starts setting out the pathways that the board in principle approved back in March of this year. Then it sets out some proposed definitions or explanations of what the 4 guiding principles mean, and that's there so that hopefully everybody reading it gets a common understanding of the principles underpinning the proposals that they'll make. Then you have a much more detailed section that sets out what we expect to see. We call these the indicators of compliance, and we've divided that into those that we think should be mandatory, and so therefore that any proposal must demonstrate, and those that we suggest can be recommended. And when people are responding to the consultation, we hope very much that they will tell us whether they think that we've got the right things in there and whether we've got them in the right place as between mandatory and recommended. Now, reiterating what Sir Andrew said, just because we don't say something must be done doesn't mean to say that it mustn't be done. So that's really important. Just because we don't prescribe doesn't mean that we don't proscribe. So hopefully that's something that people can bear in mind. And I should say that actually we have found that idea unusually not well understood. So if we can improve on that understanding through tonight's discussion, that will be very, very helpful. There's a further section that will be very important to prospective providers of training for the bar to the Authorization Framework that is not yet in the public domain, but we hope will be by December. And that's what we call the evidence document. So this is a list of the types of materials, documentation that we would expect a provider to be submitting or drawing on in order to demonstrate to us whether their proposals were meeting the mandatory or recommended criteria. For higher education institutions who are quite familiar with this kind of programme accreditation process, much that's in the framework and indeed the evidence document will not be particularly unfamiliar. But for people who are thinking about this for the first time, it might be less familiar. In particular, you'll see in the consultation, and we'll talk about this a bit more in the discussion, that the framework overall will apply to those organisations that are providing work-based learning and only work-based learning. Put in terms that many people in here would understand better, what we now call pupillage training organisations will also have to comply with the framework in due course. My colleague Julia will say a bit more about that. But we think that it's going to be very helpful to provide, in essence, a subset of the framework that's focused on those entities that just want to provide work-based learning. So on chambers, for example, that just want to provide pupillage, because there's an awful lot of the framework that, frankly, is unnecessary and doesn't apply to them, and we wouldn't want them to have to plough through all of it in order to be able to get to destination. So, developing the framework is a very iterative process. There's some big policy questions in the consultation, and we can't finalise the framework until we've actually taken the decisions on those policy points. So that's another reason why, for obvious reasons, it's just in draft at the moment. Final aspect of the consultation that, as I say, we're not majoring on significantly currently, and certainly won't be doing tonight, is the review of our curriculum and assessments, which is a very important contributor to the final authorisation framework. Again, we've got a working group that consists of both internal and external experts, and what we're looking at there is how do we ensure that students are learning things at the right time in their training, and that they're being assessed at the right time and in the right and most appropriate manner, so that we can be sure that by the time they get to authorisation, all the requirements in the professional statement have been met. And similarly, the principles of accessibility, affordability, flexibility, high standards, obviously are at the heart of the curriculum and assessment review. I mean, one of the typical sorts of questions that we will be answering in that review is, well, are the centralised assessments that we've got now the ones that we want to continue to have? Okay. Are there things that people learn currently at the bar professional training course stage that actually it would be much more appropriate if they learnt during the pupillage stage? So that's the kind of question that that review is looking at. I think that's probably enough of that. We're going to move on to the specifics of this evening's discussion. And before I hand over to my colleague, I think Chris is going first, aren't you, Chris, to talk about the role of the Inns of Court component of the consultation, just wanted to say something about our approach to this consultation overall. As Sir Andrew has said, we've got quite an open mind on these policy questions. It's really important to understand that prescribe difference. We have to, as a competent regulator, consider these things from first principles. Okay? And we have to consider the system in its entirety, how it's organised. We've got regulatory best practice and statutory guidance that we have to comply with. And we can't comply with that guidance if we haven't looked at these things from first principles. Nor indeed, obviously, can we execute our public protection role. Against that, of course, we have an obligation to make sure that we're not regulating unnecessarily, that we're not actually imposing regulation where there doesn't need to be any. And that's, again, why we're looking at some of these topics very much from first principles. So, enough from me. Sir Andrew promised you wouldn't be lectured at. I have a feeling I've already broken that promise, but perhaps Chris and Julia in their turn will retrieve the situation.